Okay. If you'll come to order, please. If I could have your attention, please. First of all, I want to thank everyone for being here and welcome you to the House Judiciary Non-Civil Committee, our only scheduled meeting of this week. We have 3 bills on today, actually 3 bills and a resolution. I wanted to take care of just a little housekeeping first in terms of timetable for today. The chair and others have a meeting with the other chamber on a fairly important piece of legislation later this afternoon, so we're going to try to end here by 3:30 regardless of where we are at that point, and anything not finished will be carried forward to the next meeting. Let me recognize our judges of the day. Judge McGarity, always pleased to have you. Thank you for being here. I showed Judge Quillian Baldwin. Oh, okay. I didn't see him. So, Judge Kent Lawrence. Oh, I see. There's only a big column between you and me, Judge Lawrence, and I couldn't see you. From Clark County. Pleased to have you, Judge Jeanette Little from Troup County. Thank you, Judge Little, for being with us. Okay. All right. With that, I'm going to recognize Representative Collins on House Bill 983. Okay. Before you begin, Representative Collins, I want to recognize the Vice Chairman of this committee.
My committee heard this bill yesterday, and we recommended a due pass on it. There was no objection voiced by anyone to this bill when it was in subcommittee yesterday.
Thank you, Vice Chairman Mumford. Representative Collins.
Thank you, Mr. Chairman. Which one you got?
The one to your left.
Left. Yes, there we go.
Do you need them both?
No.
Okay.
I appreciate it, Mr. Chairman. I bring to you House Bill 983. This bill is basically been sort of dubbed the Fresh Pursuit bill. I want to just real quickly clarify after subcommittee yesterday what the bill does. It clarifies language that allows law enforcement agencies on the border. It allows them to cross over into states who have reciprocal agreements already with Georgia. And for instance, and I use the example, if an officer in Tennessee was in fresh pursuit of a felon coming into Georgia, they would be allowed to come into Georgia, make the arrest, and then upon arrest, they take them to the local Georgia MAT court judicial officer for a hearing where they would be determined if the arrest was valid, if it was improper, made with this law and with other, and it was invalidly enforced. At that point, if the judicial officer finds that the arrest was invalid, the person will be let go. If the judicial officer, however, finds out that everything was found and proper, at that point they will be turned over into the jail in Georgia and await extradition through the normal extradition process. The good thing that a couple of just real quick things that came up. One is, does this apply only to those with reciprocal agreements? This was a concern that was raised by some in the Sheriff's Association. It only will apply to those states who have reciprocal agreements in place. Currently, Georgia and Alabama are the only ones that don't have this in place. So if we pass this, it would only be with Alabama would be the only one we would not. The other thing is from my perspective in looking at this bill, it actually helps with extradition. It tightens our extradition process so that instead of there being any agreements or anything, the person has to go through proper procedures, and it just simply puts everything in proper order. I would be happy to answer any questions you might have.
Questions from the committee for the author? No one had signed up on this one. Let's see. Is that okay? No questions down there. Is it Representative? I'm trying to determine if that's you or Representative Abrams. Okay. Representative Benfield.
Thank you. Just a quick question. I am concerned about Alabama. Do you know anything about whether they'll be signing on? I know back when I was working as a public defender, I used to always have to deal with Phoenix City, Alabama. Those of you in law enforcement will probably recollect there's a lot of I don't think anything good happens in Phoenix City. My apologies to anyone who's from there, but that's just an example of where there would really be a need for some reciprocity.
Well, I appreciate the question, and I agree. This is really where this bill came forward so that we could get some continuity among the states in handling these issues. In Alabama, I know there is some issues in Alabama with how they currently do even inter-county kind of issues. So my hope would be by us going ahead and passing this, everybody around us it would at least give some emphasis for them to consider it and put it forward in their legislative session.
Did you say if Tennessee and North Carolina both have this now?
Everyone surrounding us has it except Alabama and ourselves.
Okay. Not that I would ever want to know about that.
But just curious.
Further questions from the committee?
Mr. Chairman, Alabama's not holding
Chairman
out on
Knox.
this. I'm sorry. Alabama isn't holding out on this on kind of water, is it?
I would hope not. We'll just put a block down there and fix that.
Final call for questions from the committee. Representative Setzler.
What is the current practice now? If there is a serious offense, the law enforcement officers took it upon themselves to chase someone across the border. How would this be governed today?
Well, it's my understanding, and if you would like further clarification, I do have Officer McDonough here with the State Patrol who can clarify. My understanding is it's sort of a mixed bag, and I hate to say that it's a sort of the old buddy system agreement, but really there's no agreement in place for them to come across the border. So sometimes they'll lose them in state, sometimes it's and I'll go back to the old stories from my dad with being a state trooper. It was the old saying, well, we'll get them back to the state line and you come pick them up. So, I mean, there's all kinds of things. Right now, I believe all the law enforcement in Georgia and all the rest of them want to do it properly, and I think this will allow them to do it properly. It gives good protection for them, but it also provides protection for the accused.
So the law is basically silent on this right now.
It's sort of an issue that where we need to clarify it so that those on the border can handle it.
Okay. Further questions? All right. This is your chance. Chairman Franklin.
Thank you, Mr. Chairman. I was curious on the first page, lines 23 and 24. You're using the language that they have to be pursued for an offense that's punishable by death or imprisonment in excess of 1 year, and that seems like if they're going to be punished by death, why is that other provision just in excess of 1 year? Why not in excess of 20 years or 10 years? Or
Well, Mr. Franklin, this is a felony language, and really what it basically is death or a felony, 1 year, and that's really just the language is put in for felonies. This is not a bill that is intended to take it, just open up the borders and you go do what you want to do. This simply was the language that was initiated in there for felony. To clarify it.
Because I think we've got a bill on our calendar today, Mr. Chairman, that some misdemeanor traffic offenses can have a 24 or 36 month sentence. Is that correct?
Rumor has it that bill's on the calendar today.
So if a state had some misdemeanor traffic offense with a 24-month sentence that's not a felony, they could take advantage of this provision. Is that right?
Oh, this will be where and if you go down to numeral 2 on page 2, I think where it's the judicial officer will conduct the hearing to see if this was a lawful arrest underneath these provisions. So I would leave that in the judicial officer's hands at that point.
But the judicial officer would determine that was that offense, could the pursued individual be in prison in excess of 1 year for a traffic offense, and determine yes that they could have in their state. Would we be better off to say punishable by death or upon conviction of a felony, or would that be better language? Just so there's not that we wouldn't be allowing someone to enter our state that would to pursue someone for a misdemeanor offense.
Well, I think that's where, and Representative, Mr. Chairman, I agree with, I understand maybe your concern here. I think what we've tried to do here with the language is to just create with this only a felony issue, and I understand the probability. This is already encompassed in a lot of other things when you deal with sentencing requirements and guidelines where they look at other states and determine how some states give a little more for others. And our judges currently have to deal with this in their sentencing and prior conviction stuff. So I think at this point, I think it would be clarified in the language that's currently written. But I appreciate your concern.
Representative Abdul Salam.
Thank you, Mr. Chair. Representative, will you explain to me line 21 on page 1, where it talks about the authority that's granted shall be limited to criminal offenses of the pursuing state that are also criminal offenses under the laws of this state. Would that mean that each of the surrounding states would be required to be familiar with our state laws?
I think, Representative, what it basically says is that the laws, where it says shall be limited to criminal offense of the pursuing state that are also criminal offenses in the state. In other words, the language here gives leeway for possible differences in law. I think that Representative Franklin spoke of. I think currently, if you go to any jurisdiction that is on the border, they have a pretty good working knowledge of what goes on in the neighboring states, especially border states, because they do this all the time. This is not a new occurrence for them.
Okay. Follow-up question, if you don't mind. In terms of page 2, line 2, when it's talking about without unnecessary delay, can you elaborate a little bit more on what that means, and where will the detainee, I guess, be housed until that judicial process takes place?
Well, I think the unnecessary delay issue here is if an officer comes in and makes an arrest and has someone in their car, they really not there to ride them around. So I mean, they're going to take them to the jail there in the local county in which the arrest is made. For example, coming in from Chattanooga, Tennessee area, you're in, I think, Whitfield County, I believe, bumps right there. You go into the Whitfield County and they'd be taken to the jail there, and the proceedings would take place from that point.
So it'll go to the nearest jurisdiction where they're apprehended.
It would go to the jurisdiction of record. So if they're in Whitfield County, go to Whitfield County. If they were in Fannin County, go to Fannin County. If they were in Muskogee County, they go to Muskogee County. They go to the nearest jurisdiction.
Thank you.
From the committee, Representative Mangum.
To my distinguished colleague,
Yes.
Is this a practice that is employed by other states? Would this be a reciprocal thing, one? And two, are there other jurisdictions that employ such a practice?
The answer to both those questions is yes, and on everyone except Alabama currently and Georgia currently have this law in place.
So the only other states, so if someone's coming from Georgia to South Carolina in hot pursuit, you're saying that this procedure would be employed. Is it pretty standard type of practice that we're just catching up with, or is this something that you're trying to make Georgia the lead in?
No, we're not leading by any means. In fact, of our neighboring states, us and Alabama are the only two that don't have this. So Georgia, Florida, South Carolina, North Carolina, and Tennessee currently have these provisions already in place.
Okay. Thank you.
Further questions? Further questions from the committee? Did you ask? Yeah. Vice Chairman Mumford is recognized.
I'd like to move a due pass on this bill.
We have a motion and a second that House Bill 983 be given a due pass recommendation. Is there discussion on the motion? Any discussion? Any discussion on the motion? Hearing none, all in favor, please indicate by raising your right hands. All opposed? Motion is approved, and it will go to the Rules Committee with a favorable recommendation. Thank you, Representative Collins. Good job. Representative Mangum.
Is that the first law that is passed? Bill that is passed out of here unanimously?
You mean this session?
This session.
While we're moving on, I'll let Diane check that. It may well be.
Thank you. I don't remember that.
Representative Benfield, you think you can take that? Be as brief as Representative Collins with your bill, since it's his second appearance?
Yes, I'm happy to be brief.
Oh, man.
Otherwise, you're going to get behind Representative Levitas.
I do not want to.
I didn't think so. Absolutely. We know Amy.
Thank you, Mr. Chairman and members of the committee. I want to thank those of you. Oh, well, we have a special guest, Mr. Pete Williams. Some of y'all may recall he has been before this committee before.
Thank you.
Mr. Williams, I hope I remember 21 years that you served for crimes that you did not commit, and he was exonerated thanks to the good work of the Georgia Innocence Project. And Mr. Williams' case, as with the other 7 exonerees, or the other 6 exonerees, 7 total, he was convicted largely on the basis of eyewitness identification testimony. And that is his case, along with the others, is what led us to form the study committee. I want to thank Representative Setzer, who served on that committee with us, and Representative Mumford for the good work they did. We've already presented this bill and resolution to the committee before, so I think I'll just go over the changes, or do you want me to go?
No, I think that'd be appropriate.
Okay,
and we're taking these up together, right?
That's correct.
Okay.
The first change to the bill, and we're looking at a substitute to House Bill 997, is on page 2, lines 12 and 13. We simply added, at the request of the Sheriff's Association, that the training procedures that are developed for the eyewitness identification training for law enforcement, that it be done in conjunction with the prosecuting attorney's council, and the prosecutors are okay with that. So that's the first change. And then the other change was a little more difficult to get the right wording, but it's on page 3, and this has been I guess I could say a point of contention with the prosecutors and the defense bar throughout this process, is trying to craft language that we would all find acceptable with regard to admissibility of the eyewitness procedures. Those of you on the committee know there was significant debate about that, and I think we're all in agreement that eyewitness identification should be an issue to be addressed by the jury, should be the subject of cross-examination, and let the jury decide, let the judges decide. So we had to craft language that would make it clear that failure to follow these procedures, the law enforcement procedures for eyewitness ID, will not, in and of itself, result in that testimony being thrown out of court. So I think I've got support of all the affected parties, the prosecutors and the defense bar, on that language. And then I'll move to the resolution, and then I'm happy to entertain questions. The resolution, this is the substitute to the resolution. This is the same language that you've already seen, except we have just cut it down to what are considered the bare essentials, the basic essentials of best practices for eyewitness identification. I can easily sum them up. Whenever possible, there should be a neutral administrator conducting the eyewitness procedure, the lineup procedure. Prior to the witness viewing the lineup, the witness should be given basic instructions, and those are listed A through E. And then the third is that there should be some recording of the identification. And we left it up to the law enforcement agency, whether that recording be in writing or video or audio. But there should be some contemporaneous recording of the identification. So those are the changes. I'm happy to answer questions about the substantive merits, but I also want to be respectful of the committee's time, and we've already considered this bill once before and the resolution. And I don't know if Amy wants to add anything. Mr. Williams, would you like to say anything? I know we're honored by your presence.
Well, I would like to say that any type of procedure that will alleviate some innocent persons, that I'm all for it.
Thank you very much. Thank you for being with us, too. And again, Representative Benefield, thank you for the good work you did on this over the interim. All right, Representative Abdul Salam.
At the appropriate time, I'd like to be recognized for a motion.
Okay, let's see if we have questions first, and I will come back to you. I'm just.
This is not here, and I actually don't need.
I just I'm trying to find an occasion to call you Jacobs today.
If it makes you feel any better, Chairman Knotts called Representative Jacobs this morning. All morning long. 3 or 4 different times.
Chairman Franklin.
Thank you, Mr. Chairman. I've got a question on the resolution. It seems that the only thing we're resolving is on page 2, lines 24 through 27, basically, that law enforcement agencies are strongly urged to develop these policies. And am I reading this correctly?
You are, but it should be read in conjunction with the bill. And I didn't go over all the key points of the bill since we had reviewed it. But if you'll look on page 2 of the bill, you'll see that.
But what I'm trying to get is the resolution itself is that it's just urging the local agencies to adopt written policies based on the findings of a study committee. That starts with the whereas on line 21 of page 1.
That's correct, but the bill mandates that there shall be, if a law enforcement agency is conducting lineups, that they shall adopt written policies. And then the point of the resolution was to set forth what the study committee found to be the best practices, and all of these best practices are data-driven and backed by science and by the experts that we hear testify. So this is just providing guidance to law enforcement as to what the best practices are, but we're leaving it up to their discretion. We didn't want to mandate, and that was a key point with law enforcement and with the prosecutors, that they didn't want to be mandated certain specific procedures. So the compromise that we worked out with the prosecutors and with the police, and I understand the sheriff still has some concerns, and you can hear from them, was that we would put it in the form of a resolution that's non-binding, that would set forth what we consider to be the basic best practices.
Thank you.
Representative Setzler.
Hey, Mr. Chairman, just to Chairman Franklin's question, the study committee considered a number of actions done by other states. North Carolina, for example, went through a similar process, not necessarily a study committee, but looked at this in detail and came with a very, very prescriptive piece of legislation that said, doing lineups in North Carolina shall be performed in such a way. And I certainly had a concern, I think many members of the study committee had a concern, that if we were that prescriptive, then any moderate deviation from the prescriptive regimen they had to follow would cause the evidence to be not admissible or thrown out or impugned. So the resolution kind of urges law enforcement agencies to follow it because there were some best practices established. There's just a real concern that we could trip ourselves up and have some unintended consequences if we mandated very, very carefully things that law enforcement agencies had to follow, recognizing the diversity of law enforcement agencies in the state. So I think this is a sort of a hands-off approach to kind of accomplish the same thing.
Okay, thank you. Any further questions? Further questions from the committee? What's the committee's pleasure? I'm sorry, Representative Abdul Salam.
Thank you, Mr. Chair. I would like to move due pass on the committee substitute to House Bill 997 in conjunction with the committee substitute to H.R. 1071. One at a time?
Yep.
Okay. Restate. I would like to move due pass to committee substitute to House Bill 997.
Is there a second? Second. We have a motion and a second that we give HB 997 a due pass recommendation. Is there discussion on the motion? Chair recognizes Representative Lunsford.
Thank you, Mr. Chairman. Actually, I didn't really have a question about the due pass motion. What I had questions was we've inferred during this conversation that we'd reached agreements with the parties that are affected, such as the DA, solicitors, judges, and sheriff and police. I was hoping that we could have some input from them in this meeting as well, and prior to passage of a bill, and make sure that they are comfortable with it, since we're mandating how they have to do their job.
We had two that had signed up, and I know we have the motion on the table, but I'm going to take their comments out of turn, but we'll still have the motion, due pass motion on the table. Thank you, Representative Lunsford. Two people had signed up on this one. Chuck Spahos.
Yes, Mr. Chairman. I'll just take a minute to say that the representative should be has worked hard, and we come to an agreement on these terms, and we do support her efforts.
Okay, thank you. And Terry Norris with the Sheriff's Association.
Thank you, Mr. Chairman. I also would like to thank Representative Benfield for the hard work. She spent a whole summer working on this, and be the person that kind of gets up here and kind of throws some water on the fire a little bit. The bill itself, we're absolutely okay with. we do have concerns with the resolution. It is non-binding. It is not mandatory that these policies be followed. In fact, she was very kind to hear our concerns just Monday, I guess it was, about the resolution, and she actually improved the wording for us in that regard. That resolution does not have the force and effect of law, but it is public policy. Once it is passed, the House of Representatives, it is public policy of the highest esteem. And while it, again, is not binding that the sheriffs and the chiefs do anything particular, we do believe that that message that you all are sending will create grounds or an avenue for appeal down the road. Now, I am always intimidated by this highly esteemed group of attorneys and others, and I'm not an attorney. But I have talked to sheriffs, and they are deeply concerned with that aspect of it. Footnote the conversation is, and this is not crying over spilt milk or fussing about what the sheriffs have to do, but unlike any other local law enforcement entity in this United States, not just Georgia, the sheriffs do what they do because this body, these bodies, and the governor tell them what to do. They're very good at what they do. They attempt to use best practices throughout whatever the endeavor it is that they partake of, and there's none of them out that is not going to continue to do best practices or continue to do best practices. But I urge you to understand that when you pass this resolution, you're passing and adopting public policy that may change. The best practices may change over the next weeks, months, days, minutes, whatever. So you're placing in law through a resolution some variables to a very important function that could change over time. But thank you for the opportunity to speak.
I think you've drawn a question, Mr. Norris, if you want to answer it.
Oh, yes, sir.
Secretary Bearden.
Mr. Norris, thanks for being here. So the Sheriff Association's fine with the bill?
Yes, sir.
Okay.
And may I respond further?
By all means.
I should have said going in, we absolutely welcome the opportunity to improve practices. We do. We think the bill establishes those practices, tells us what needs to be done, and we think the resolution as a result is not necessary.
Okay, thank you so much.
Thank you.
I actually have a question for Representative
Abrams.
Representative Benfield, to the sheriff's concern, is it not true that Georgia law does not permit the inclusion of legislative intent as evidence unless the legislation in question is patently unclear? So that to his concern about it being grounds for an appeal, this bill is fairly clear on its face. In fact, it's patently clear on its face that it is intended only as an urging resolution and not as an act of law, and therefore it would not, the legislative intent would not be permitted as introduction as evidence should someone appeal a decision of conviction.
Thank you for making that point, and that is exactly what we discussed in our meeting on Monday, we did stress to the sheriffs that no lawyer is going to bring in a resolution and wave it in front of a jury. What would be brought into court and what is allowable under Georgia law is the written police procedures. That would be the appropriate evidence that would be used to cross-examine any law enforcement officer or administrator of an eyewitness procedure. So the resolution is simply urging, and I would stress these are best practices that are universally agreed upon. And if you read over them, you'll see a neutral administrator whenever possible. I don't foresee that changing in 10 years or 20 years, that you have a neutral person administering the lineup. That's basic, in my opinion, and also in the opinion of the experts all over the country, that the witnesses be given basic instructions, and that a recording be made of the identification at the time. These are really bare bones. And I have the U.S. Department of Justice report that was in-depth, and it consulted experts from all over the country. You see how thick their report is, and I've condensed this report of best practices to what are absolutely considered by all the experts best practices. And I will stress that the prosecutors in the room, we were all in the room together on Monday, the ones who will be arguing the admissibility in court, agreed that the resolution and the language that we agreed upon was okay, and they're the ones who are actually going to be in the courtroom dealing with the admissibility issue, and they were supportive of it. Okay. And, well, the chiefs of police are here as well. I certainly don't want to speak for them, but I know that they are supportive. and the Georgia Bureau of Investigation. Again, I don't want to speak for them, but I can say as of Monday they were supportive.
Okay. Further, now we're back to discussion on the motion to do pass. Any further discussion? And just so that we're clear, the motion would be by committee sub, and the one we're talking about is LC 293128S. Anybody got any questions about that? Any further discussion? Hearing none, all in favor of the motion, please indicate by raising your right hand. All opposed? We're having unanimity today. Representative Mango?
Oh, I guess I could vote too, can I?
Yeah.
Put me down as a yes.
Okay.
Yeah, I just realized I'm on the committee.
All right.
Put me down as a yes.
What is the pleasure of the committee with regard to H.R. 1071? Representative Randall.
Thank you, Mr. Chairman. I move do pass on H.R. 1071.
We have a motion and a second that
by committee substitute.
that we give H.R. 1071 by committee sub a do pass recommendation. Is there any discussion on that motion? Any discussion? Did you, Representative Abdul Salam?
Thank you, Mr. Chair. Just for the sake of clarity, I would like to just ask that the purpose of this resolution is to prevent others from sitting next to you that have served 20 plus years of their life for something they didn't do. Is it not a small precaution to take?
Yes, I agree.
Further discussion on the motion? Further discussion? Hearing none, all in favor of the motion to give House Resolution 1071 a do pass recommendation by committee sub indicate by raising your right hand. The speaker said today you could vote against your motion or something to that effect. All opposed? And the vote is. The motion has carried by a vote of 10 to 5. That will be sent to the Rules Committee with a do pass recommendation. Thank you, Representative Benfield. Thank you, Mr. Williams, for being with us today. And thank you, Ms. Maxwell. Tell her I treated you good. All right, House Bill 336, Representative Levitas.
Not in your best interest.
All right, if we come back to order, please. Representative Levitas.
Thank you, Mr. Chairman. I'm hoping that we'll be continuing along that theme of unanimity. I like all those hands in the air. I thought about moving for due pass at that time. Mr. Speaker, the leaves have fallen off. Mr. Chairman, the leaves have fallen off the trees, and winter's come, and 336 and my lovely charts are back before you, and I appreciate the committee considering this bill again. As you will recall, Mr. Chairman, this passed out unanimously but did not make it out of rules, and it was referred back here. And as much as it pains me to say this on the first time, I'm glad it did, because what it did is give me an opportunity over the summer to meet with just about every single stakeholder that I could possibly think of on this bill: judges, Department of Driver Services, Department of Human Resources, prosecutors, everybody, service providers, everybody I could think of that had an interest in this. And what came out of it, I think, is a much improved bill, and that's what you have before you.
I really don't want to spend a lot of time unless the committee is really interested in hearing me pontificate. I just want to explain the changes from last year to this year, and answer any questions, and of course, if there's any testimony that you want me to give. What you have before you, the most significant changes to this bill. In the prior version that you had, there was the first offense was a misdemeanor, the second offense was a misdemeanor, and the third offense was a felony. We are proposing in this bill, the substitute, to have a first offense as a misdemeanor and create two new misdemeanors in the state of Georgia. One is called a 24-month misdemeanor, and one is called a 36-month misdemeanor, and they are just what the name implies. They are essentially a high and aggravated misdemeanor that is a 24 and 36-month misdemeanor, and the offense of driving under the influence would not become a felony until your fourth lifetime. The reason for having the 24-month and 36-month misdemeanor really came out of the DUI courts and the state court judges who had requested of me more time to work with the folks in their successful DUI court programs. That 12 months was just not enough to get the job done. It also addressed a concern that the Department of Driver Services had because the interlock provisions essentially were supposed to go on after 12 months, and of course, once the sentence expired, there's really no way to comply with that. So that was intended to meet those two concerns. If you would like, I can go over the punishment provisions. I think they're there for you, but I defer to the committee's pleasure. And as I said, now the fourth offense is now a felony, fourth and subsequent. The other significant change is with regard to the treatment of violators under 21 years of age, and Representative Setzler had addressed some concerns with regard to those provisions last year. I took a look at several model statutes that are out there on DUI bills and became convinced that the best way to deal with this was essentially to treat them, for most purposes, as regular violations. If you'll note, there's a little green box there that just talks about the treatment of violators under the age of 21, and that convictions under the ordinary adult subsection K, for folks under 21, which is subsection K, they count as convictions as a regular DUI, adult DUI, for sentencing purposes in a 10-year period. There are some provisions in the 21-year-old statute that allows them to serve on weekends. Other than that, it's more or less the same. The only other things I wanted to mention, Mr. Chairman, was that there is the Governor's Office of Highway Safety in its 2007 Strategic Highway Safety Plan and the Young Adult Driver Task Team 2007-2008 expressed support for a felony DUI bill in those reports. And I do want to mention one statistic that did grab me, in addition to one that people in this committee may be familiar with, which is that there is a DUI death about every 30 minutes in the United States, is that in 2005-2006, Georgia was one of the states that has a 7.2% increase in the number of DUI deaths, and we are one of 5 states, including California and Massachusetts, who already have a felony DUI statute, that does not have a DUI statute. And I would respectfully request that the committee give a due pass recommendation.
The chair was just wondering if maybe we could refer the Code Revision Committee, when they meet next year, to see if we could put this, assuming this were to pass and become law, put this in the code. Might be of
value. I also will offer to fill out any NCAA brackets that you would like me to complete for you.
Representative Mangum.
Thank you, Representative Leviticus, for bringing this important legislation. I am aware that there are efforts by many who have given me the understanding that drug courts in our states have been rather successful. Can you tell me what, if any, impact the programs that are in place, how that works with this structure that you have for the DUI?
Thank you for the question, Representative Mangum. This is made actually to work with those courts by providing the 24 and 36-month time frames. It allows the court, these DUI courts, I've been to a few of them, met with the judges. It allows them the kind of tight and lengthy supervision that they say they need to make these programs successful. They apparently have a very good non-recidivism rate. And my preference would be that number 4, the felony never comes to bear. There is a point at which I become more concerned with safety of citizens than I am with the rehabilitation. Someone having 3 bites at an apple, to me, especially something that I would suggest to you is a violent crime, that somebody's got a loaded weapon when they get behind the wheel of a car. So this was made to work with them. And if I may, Mr. Chairman, one provision I've neglected to mention, we did add a provision for the red stripe of licensing, which already goes on currently in the code. That is a one-time event. I have made that a recurring event if there are a number of offenses within a 5-year period.
So it is my understanding. For example, there's one you may know, one of the judges in DeKalb County who has been a strong advocate for the drug court system. Did you by chance have consulted with those persons who were doing that, or that particular judge in particular?
I have. There's Tony Del Campo is somebody I met with over the summer. I've also talked to Judge Wong. I've had several conversations, and either in your folders now or being passed around is a letter of support from a state court judge who's been doing this for 25 years, who has expressed his support for this. I don't presume to speak for the judges or for the prosecutors, but I think that the prosecutors are here today. I will tell you that I vetted this with all of them and was told that there was no objections.
Okay, I thought it's neither one of the 2 judges that you've named. I've been in hearings where I cannot think of the judge's name. There's only a few of them, but I can't think of his name.
Was it Panos or Purdom?
No.
Wong?
Superior Court level.
Oh, Superior Court level.
Superior Court level.
You're talking about Judge Castellani's drug courts?
Not Castellani. Well, okay. I'm not going to call every judge's name in DeKalb County. But
it wouldn't take a lot longer.
Yeah, you're right. Well, but it is my understanding that you have. My simple concern is that you have had some contact and that this is consistent with what they're doing rather than contrary to what they're doing. I don't know whether they have a lobbyist to come down here and pay money to say, oh, if you made it 25 months, it would fit right in, but if you make it 24 months, it's going to cause us this problem because, we have this successful. I can't think of that judge's name. I'm sorry.
I'll confer with you afterwards and give you
Sure.
right out a list. But of course, this would be a little bit different because the DUI courts are happening down at the state court level, whereas the drug court that Judge Castellani and some others are running as a Superior Court level judge. It would be my hope that as the Superior Court develops an expertise in this area and as it sees more cases, that things like a DUI court at a Superior Court level would occur. But I just wanted, answering your questions, I wanted to refer you, if I can lay my eyes on it, there's a specific section in the bill that refers to the drug courts and essentially says that if they've never been to drug courts before, that they may go to them, and the sentencing provisions won't apply to those folks who are under supervision of a drug court, or for those areas where there is not a DUI court, where there is a substantially similar program that the court approves.
Where is that provision, sir?
I knew you were going to do that to me, Representative Mangum. Page 10, I'm being told. And it begins provided, however, I believe it's line 24, beginning of line 24 through 29.
Okay, give me a different page. Mine is not speaking to that issue on page 10.
Page 10, are you on 3118S?
Okay.
Mr. Chairman, while Representative Mangum's looking at that, if I could just ask for a one point of personal privilege, which is to thank publicly all the work that Counsel Travis put into this bill. She did not, against her better judgment, block any of my calls or refuse to see me at a certain point, but she has spent many, many hours, weekends, working on this, and I just want to publicly thank her for the job that she has done to help craft this.
What do you think?
She's not responsible for anything that's not good, but everything that is good, she's drafted.
You're not suggesting that the chair or any member of this committee blocked your calls, did?
I'm not suggesting that, no.
But you have strong suspicion. Is that what you're saying?
Until there is a move due pass and a successful vote, I have no comment, if I may.
Okay, can we wrap up the,
I'm okay, I guess.
Okay, thank you.
I'm gonna allow.
Vice Chairman Mumford.
Good afternoon, Mr. Levitas. Fortunately for you, I have to go present a couple of other bills and other committees in just a moment.
I would have tried to talk slower if I had known.
But I thought the definition of a misdemeanor was 12 months. I know we have high and aggravated misdemeanors, but how are we getting to the point where we have misdemeanors that go for 24 months and 36 months?
Well, I mean, and this is really not a flippant answer, though it may appear to be. The 24 and 36 months are there because we say they are. And this is not something that we came up with.
Isn't there a definition in the code of a misdemeanor somewhere else?
There is a definition of a code.
Are we changing that?
No, we're adding to it. And in fact, if you look at the code provisions in the bill, it says that in order to avail yourself of this provision, you must invoke the terms 24-month or 36-month misdemeanor, and that they are treated as misdemeanors for all, or high and aggravated misdemeanors. That actually leads me to a point. High and aggravated misdemeanors for all other purposes except punishment.
And if I understand the concept of your bill, the idea is that this is going to give people the right to go into drug courts and be under supervision for longer than they would be if they just pled under the current code and went to prison for 12 months.
Well, two things. It would give the drug court or DUI courts an opportunity to rehabilitate, give them the time that the DUI judges.
But then in the back of this bill, isn't there a get-out-of-jail-free card because you go to drug court and then none of this stuff applies?
You get one shot at drug court. That's it. And so my hope is that it is a get-out-of-jail card to the extent that under the supervision of the DUI courts, they would be rehabilitated and never reoffend. But I will tell you that the reason that I want that felony in there is having given folks an opportunity, and they only get one shot at it. If they have not availed themselves, and the DUI court judges will tell you the same thing, at that point, they're just about ready to wash their hands of them. They say, go ahead and go after them.
Well, I don't have a problem with having a fourth offense felony. What I do seem to have a problem with is how we get there in between. I also, just before I go, because I unfortunately have to leave, we are treating under 21-year-old drivers with a BAC of a .02, which is the zero tolerance rule for under 21 drivers. They are going to be, if you get such a DUI and you're under 21, that is going to count against you under this scheme that you've proposed in this.
It would, except that if I remember correctly, and counsel, you may have to help me with this, I believe that after 10 years, those drop off. And keep in mind that you would
have... Do any other DUIs drop off currently under law?
Well, basically all of them do, and that's the problem with the bill. Oh, sure. Because what happens is you've got 5 years. The punishment currently under law is within 5 years.
If you run someone's driver history, those DUIs show they could be 40 years old.
Oh, they'll still...
You're talking about them dropping off for purposes of whether they're held against you and a penalty on your driver's license.
Right, and that's the same thing in this case.
You're actually going to change it so that an under 21 driver will not have a DUI conviction showing it anywhere?
No.
Are you saying it for 5 years?
As you pointed out, for the purposes of punishment only, it will show up on their driver's history and should show up on their driver's history. And one of the concerns was expressed last year is, aren't we being too hard on these folks? In order for them to hit this, they would have to pick up a whole bunch of convictions pretty quickly. In other words, there's only a 3-year window when somebody is between the ages of 18 and 21. So I don't have a lot of sympathy for somebody that picks up a felony amount of convictions within that 3-year window.
I have one more follow-up, and I'm going to have to leave. You would agree with me that this scheme you have is designed for those courts that have drug DUI alcohol treatment programs. Is that correct?
No, I would not agree with you. Or I would agree with you to the extent that it addresses those, but it also gives in that same code section the power of a court where there are no DUI courts to approve a supervision program that is substantially similar to a DUI court.
You would agree that the vast number of municipal courts and probate courts and other traffic courts and even state courts in this state do not have such programs at this time. Is that correct?
Absolutely, and it's something we as legislature ought to be funding in greater numbers.
All right. Thank you very much. I have to be excused.
Okay, the chair. We have a number of questions, and the chair is going to do my best to get these in the order that I saw them blinking. Representative Abrams.
Thank you, Mr. Chairman. Mr. Levitas, on Section 8 on page 12, can you just explain the look-back provision? Specifically, this captures anyone who has a conviction on or after July 1st, 2003. Can you just talk a little bit about your rationale for doing so?
I did not. Essentially, it's a notice concern. I did not want somebody who had a DUI in 1960 and then again in 1970 and then again in 1980 to fall under the provisions of what has now become a potential felony exposure. It seemed to me that I do not at the same time want to give somebody a break who, on assuming that the governor were to sign this bill on July 1 or an effective date of July 1, I would not want somebody to get a free ride having picked up 3 DUIs by saying we're only going to look back to the effective date. So I tried to capture a window that seemed to me reasonable to look back without unfairly attributing DUIs that may have happened 30 years ago to what has now become a felony DUI statute.
Thank you.
Representative Lunsford.
Mr. Chairman, can I wave off for a second?
You sure can.
Come back to me.
Representative Setzler.
Thank you, Mr. Chairman. To the author, I do share some of Chairman Mumford's concerns with respect to the .02 BAC for folks below the age of 21. We discussed that last year, and I think I'd certainly be open to discussing that more, but that is a concern. I do, setting that aside for a moment, have another concern that I want to see addressed is, and I know you don't want to open, or you didn't want to open Pandora's box with this any more than you might already have because of some of the schemes you've got here. It's a complex bill as it is, but I'm of the belief, from a public policy standpoint, we need to be getting DUI offenders under the guardian interlock regimen as after a first offense. I think folks that are able to be rehabilitated and given a real wake-up call and really be influenced through that process frequently are first offenders who need to be watched, can be rehabilitated, and can change their behavior. They're not, I think in many cases, the long-term chronic alcoholics. In many cases they are, but in many cases they're folks that have just been doing the wrong thing. And I think that I think the guardian system introduced as a first defense remedy is an important part of the program. I'm also sensitive to that typically only coming in after the 12 months is over and the courts don't have the ability to really enforce that. I think you addressed that in the second and third offense here. That's one of the reasons you want to have the 24 and 36 month treatment. I would submit to you, if I'm going to be comfortable moving forward with a substantial change to DUI law, I believe we need to consider introducing guardian as a first offense remedy. And would you be open to that?
The short answer is that, as you point out, it's a complicated bill, and that is a very controversial issue. And I would rather not introduce in this particular measure any more controversy than is needed. And my preference would be to handle that by separate legislation, if in fact that's the will of the committee to do so. I will tell you that, again, this is DDS says that would be very difficult for them, if not impossible for them to manage. So I don't know how we would do it unless you made the 24-month misdemeanor on the first offense. And again, as you point out, you would be opening a Pandora's box. My request would be to get this bill in place if we feel like there are other things that we can do to improve the bill, to improve recidivism rates or decrease recidivism rates. I'm all in favor of that, but my preference would be to keep this bill as clean as possible.
If I could ask, what was the piece about introducing interlock as a first offense remedy? The DDS said they couldn't execute it. As I understand, it's a self-funding system, or it can be a self-funding system potentially.
It's the issue that you excuse me. It's the issue that you raised about the amount of supervision. I mean, I don't know that, and if I recall, and I don't want to speak for DDS, I think there may be somebody here in the audience who can speak better to it. There are some efficacy concerns out there about whether interlock is either necessary or is effective on the first. For my purposes of this bill, I don't express an opinion about that. I don't pretend to know. What I've tried to do, what I think is again, from my perspective, the first step we ought to take. And this is something that was raised as a concern by some committee members, but I'm at a loss to understand why somebody would object to this. We don't currently require, though most judges do, we don't currently require in statute that there be a drug and alcohol evaluation, that there be any necessary treatment that the offender submit to that. That, to me, is a good first step, is identifying if, in fact, there is an abuse problem and dealing with it on that end. And, again, if in the wisdom of the committee, or if you wanted to introduce a bill, I'd certainly work with you on that. But interlock itself on the first offense, I will just tell you out there, even by folks who are in favor of tough DUI laws, raises questions. And again, for the purposes of not introducing controversy that in this particular bill I didn't feel was needed, that's why it was not amended, as well as the administrative problems.
Chairman Knox.
I applaud once again Representative Jacobs for bringing this. I mean, Representative Levitt for bringing this bill to us. I have a concern about the interlock device as well. I thought it might be an effective deterrent to repeat offenders. It's sort of a self-governing type of device that doesn't require quite as much supervision from the sheriff's department and the judiciary and so on. It's sort of like, if you violate it, the bell goes off and they come get you and you go to jail. And so I'm not sure why that's such a huge issue. I think that the statistics are, I believe, from MAD and others say that when somebody's arrested for DUI, it's not the first time they've been driving under the influence. It's usually, there've usually been several occasions when they've done it. It's just that you've finally been apprehended. But usually it's not that infrequent for somebody to have a second DUI. And I think the statistics are that if you have more than one DUI, the incidence of death and serious injury rises dramatically after a first DUI conviction. And so that being the case, it seems to me that if you want to solve the problem of, which I think is what our idea here is, not that we're not mad at people, we just want to keep them from hurting themselves or somebody else. I think is the idea of the DUI law, as I understand it. I mean, we're mad at them, but that's not why we're after them. And so that being the case, and in light of the fact that we currently have a drug bill on the books, a drug court bill, and we have a DUI court bill also that counties can adopt if they want to, that we ought to be trying to support those by using the devices that will help us use those courts to their greatest efficiency with the least amount of cost, and at least to the court system, because that money can be spent elsewise. So I wish we'd take another look at that. I don't have an amendment to offer on that, but I think at one time we had that in the bill, and this is I think, as Representative Setzler said, it's going to be it's a complicated bill anyhow, and so I'm not sure that would complicate it a great deal more. The other concern I have about it is this, and so I'm asking you if you would consider that, putting that back in the bill. I may want to offer it as a friendly amendment. The other thing would be on with respect to codes, these new code sections with respect to a 24-month and a 36-month misdemeanor. When I'm reading the code, it says that a misdemeanor, a high and aggravated misdemeanor, means any crime other than a felony. That's the definition in the code. And a felony is an offense that's that you can be imprisoned for more than 12 months. So to me, that is the framework into which you have to put offenses, because we only have two punishments in Georgia. One is a misdemeanor and the other one's a felony, and those are the two classifications of offenses, or the punishment for offenses. That being the case, I'm not sure that we can establish a new offense in a code section in any code section without changing the definition of what constitutes a misdemeanor or a felony in Georgia, because if we'd have to change both of those definitions in the code section. That's 1613. I think in order for us to be able to pass a challenge with respect to the imposition of a misdemeanor that's more than 12 months. So I think we probably need to take a look at that. I'm sure Legislative Council looks at that and probably has looked at that and probably disagree with me on that. But the further concern I have about it is this: I don't think that once we start down this road, that a misdemeanor can be, a 24-month or a 36-month, or will it be a 56-month or a 142-month misdemeanor? It's using the term misdemeanor doesn't make it a misdemeanor. What makes it a misdemeanor is the qualification and the definition of a misdemeanor, and that's been defined, as long as I can remember, in the code as how many months a person can be required to serve for that offense, whatever it is. And so we've tried to. And that, to my knowledge, that's the way we've done it for I don't know however long, and that's what the code says. So I think at least we'd have to change the definition of the code somehow to make an exception for DUI, or for those portions of the code that apply to DUIs that are going to invoke a 24-month and a 36-month misdemeanor. So I suggest we might need to look at that. In addition to which, I'm not sure that under your scheme that we really need to be able to have a 24-month or a 36-month misdemeanor. Almost never, in my experience, and I've been in front of a number of Superior Court judges and state court judges as well. I think they all left, so I can say that in spite of the fact that I've been in front of a lot of them, I still think they do a pretty good job in most cases, and they have the discretion to impose sentences, as well as the prosecutor to impose sentences that are consecutive. And almost never do you have a DUI case that there aren't other misdemeanor charges involved. It'll be a traffic offense, failure to maintain lane, running over a dog, whatever it is. You're going to have 2 or 3 or 4 different charges besides driving under the influence. And so in most cases, the prosecutor has the ability to impose a sentence essentially of 36 months or 24 months or 48 months or how many ever charges the police officer has the initiative and ingenuity to write up for that particular arrest. So I'm not sure why we want to go out on a limb to change the definition of the misdemeanor with what I think that might imply, when we already have within the discretion of the court to impose these other sentences. So I'd like for you to consider that as well. I think that's all I wanted to, and I'll ask for your response on any of those. I'm sure you've addressed that to the Legislative Council and friends in the Prosecuting Attorney's Council, so on and so forth.
And I would not. I really don't want to take up too much time with my own answers, because there are people with more expertise out there in the field. I will, if she's willing, I'll defer that particular issue on the changing of the code section. We have done that. We labored over that long and hard to make sure that what we were doing in our best judgment was making sure that the definition of misdemeanor and these were very clear, excuse me, in being a separate creature. This is not, as I said, this is not a novel thing that we pulled out of the air. This is something that's being done, and I think it's 8 states. 8 states, and also the federal system has a more than 12-month misdemeanor. So really, the only problem with doing it is if someone says that they don't like it, they don't want to do it. But as far as being able to do it, it's out there in other states. It's out there in the federal system. I do, as far as the interlock goes, again, I think what we do if we do that, and this goes back, for example, to a bill that you will remember preceded me, But there was a DUI bill that tried to deal with the implied consent and became so bogged down in being loaded up that instead of having a good bill, we had no bill. And again, my preference is that we take the step, and as you point out, it's a complex bill and it's a major step, and we try and take that step forward. My concern, as I've said, is that if we add that interlock to the first, it is not my opinion on this, it is just my concern about what will happen to the bill if we do that, that we will lose some support that we might otherwise have. Mr. Chairman, there is one friendly amendment that I do want to mention. In the definition of the 24 and 36-month misdemeanors, there is reference to, on page 2 at line 30, it's really 29 and 30. It says.
Are you working from 3118
S?
S. And what
yes,
page?
Page 2, lines, I guess it's 28 through 30, beginning with provided, however, that in all respects except for a punishment, a 24-month misdemeanor shall be regarded as a, and I would insert the word, this was Judge McGarrett, he'd approached me about this, and I would consider this a friendly amendment, especially since the author's proposing it now, to insert the words high and aggravated between a and misdemeanor. And that would be also true for the 36-month misdemeanor, page 3, line 34.
Is there any objection to that amendment? As opposed to high and aggravated misdemeanor.
That's fine with me, Mr. Chairman.
I think Jill's correct. She usually is.
I have come to learn that over the last several months. Then that would be a misdemeanor, and then we would add of a high and aggravated nature after misdemeanor in both of those sections. That would be the amendment.
Any objection to that amendment? Hearing none, it's adopted. Okay, Representative Abdul Salam.
Thank you, Mr. Chair. Representative Levitas, thank you for your long-term work on this issue. I do have a few concerns that I would like to just ask to be considered, and maybe an explanation on a couple of areas. One of the concerns that I have is the requirement for substance abuse treatment programs. And I think, as you said earlier in your comments, there are not enough of those programs throughout the state. So how is it that we would be allowed to require that?
I may have misspoken. There's a difference between the DUI courts and the substance abuse treatment programs. Okay. There are a lot more of those around the state than there are DUI courts, and that if I misspoken and interchanged those terms, I did not mean to.
Well, I'm looking specifically at page 4, line 23 and 24, where it says shall complete a substance abuse treatment program. And I'm familiar with areas that don't have any such programs. So how would we require that?
Well, I'm not familiar with those places, and if you can show me the specific areas, because I'm certainly not aware of any place that doesn't have any kind of treatment programs whatsoever. Sure. That the court could. Then the answer is depending on where they are, they would have to go to wherever it is they need to go to get that evaluation.
Which brings me to another point. When you don't have health care insurance and you don't have resources to pay for these programs, how is that handled?
I don't know. I guess part of that's a decision you ought to make before you get behind the wheel.
Well, I think we should make that decision anyway, but you're requiring this to be done through law. And if we're requiring this to be done through law, then there has to be some consideration for that.
Well, the consideration, at least on the first offense, is that if that the judge, in his or her discretion, may have the fine in order to defer some of those costs. So that consideration was given to that, in the specific purpose, if they're undergoing that evaluation, that they get a halving of the fine to help defer the costs.
But an evaluation is not treatment.
Right. And if there is no treatment, of course, I think it's about $75, if I'm not mistaken, anywhere from $75 to $150 to get the evaluation. And if there's not a problem, then you don't have to get the treatment. But in order for you to successfully complete the program, they would have to complete, as the court directs, whatever the clinician determines are the substance abuse treatments. Now, whether that's counseling, whether that's attending AA meetings, that would be up to the particular clinician and the probation officer to decide.
And the DUI courts are in every jurisdiction?
No, and that's specifically why the bill says that it's either a DUI court, excuse me, I'm getting over a cold, or a substantially similar program that the court approves. So it doesn't have to be a DUI court, but it needs to keep most of the components of a DUI court.
Okay, and I guess my final concern would be something that I've asked about in this committee before, is the pretrial diversion programs. Would this preclude such programs?
Not if it's a pretrial program, then there's no plea entered, therefore no conviction. So no, it shouldn't. It also shouldn't affect a first offender discharge as well.
Okay, and Judge Benefield, who is one of my state court judges, talked about the substantial time for the sentence for DUI to include meaningful long-term treatment. I will talk with him further about that, but I guess I'm just not clear of what would determine meaningful long-term treatment.
Oh, but are you asking me to comment on Judge Benefield's?
Well, he wrote this in support of your legislation. I assume that there was a reason.
Right. Well, I mean, I guess I'd have to refer you back to the judge. To me, the meaningful long-term treatment is what's provided in 336.
Well, I mean, because right now, Judge Benefield does not refer to treatment, even in pretrial. So I'm a little bit confused. It's a little bit ambiguous to me. And just because of the reasons that I've stated, particularly for the people that I know that are trying to get treatment, want treatment, can't afford it, and we have no place to send them. That is a reality.
Representative Lunsford.
Thank you, Mr. Chairman. Representative Levitas, got a couple questions. On page 11, we're looking at the under 21 years of age driving. And its current code is it's 0.02 grams 3 hours after you were driving. And so I have a hypothetical for you, and I want you to just think through this with me. I'd love to have your input. You're 20 years old at UGA. You have one beer, which scores you at 0.02 grams. Now, they said you drove 3 hours ago, but they could still convict you as your first offense. So 4 years and 9 months later, you're driving down the road and get pulled over and below .06. We have raised the fine from $1,000 to $5,000. And you're now a second offender and can serve up to 24 months in jail, which I'm okay with a lot of that. But Section 1710-3 was code section I wrote into Georgia law about 5 years ago, and you played with my code section about earned time allowances. So if we take this young person and we put him in jail with the maximum incarceration, you have disallowed the earned time credits for good behavior in the work release program. I'm just kind of curious why.
Well, they're not disallowed. They would be the same as a high and aggravated misdemeanor. So it wouldn't be the same as under your statute, but it would be under the same as under high and aggravated.
Okay.
And again, keep in mind that they could not, as a 18 or 20-year-old, have the .02 twice. They've got a 3-year window where that can happen.
Right, and that's why I use the example. He was 20 years old, so it's 1 month before his 21st birthday, right. Which I understand that under current Georgia law, he can't plead nolo contender anyway, right, for the DUI. But then if we're going to incarcerate him for up to 24 months, and I am in support of your legislation, don't get me wrong, but I'm kind of, the high and aggravated originally in this code section, the 1710-3 was for family violence, someone who was violent or aggressive. We didn't want to let them out of jail early, but we were trying to give a benefit to the local law enforcement. So you have a guy in there who's a mechanic, and they say you want to earn up to 4 to 1 credit, you can work on my police cars. And then all of a sudden he realizes he's working, doing the same thing he'd be out on the outside making $12-15 an hour doing, and he's doing it for free. And here he's hopefully going to stay out of jail because you're going to make him work while he's in there. And that was the whole idea. It was kind of a middle of the road. We weren't trying to create chain gangs, but it was totally voluntary. But under this proposal, you're not allowing them to use any of the earned time. I'm just kind of curious why.
Well, again, if somebody is picked up within 2 years, essentially, 2 DUIs, I've got to tell you, I just don't have a lot of sympathy for that person, who, by the way, is not supposed to be drinking at all, much less drinking and driving under any circumstances. So, again, if you've picked up one, I can understand that. Everybody can make a mistake at some point. If you have reached the level of 2 within 3 years, that suggests to me a significant problem that needs to be treated differently than it would. And again, you're talking about a very limited window when that would arise.
Right. You say 3 years. I was thinking it was 5, because if the second offense occurred within 5 years of the first one,
but
so if they did it at 20 3/4, it could be 5 years, right?
Right. And again, if you're talking about the lifetime stacking offenses, yes. If what you're talking about, I mean, it's not possible to violate this code section once you've reached 21. Then you are a regular adult offender at that point.
Okay. Just curious. Thank you.
Thank you. Representative Ramsey.
Mr. Chairman, Representative Levitas, we started to talk about this beforehand, but we got kind of cut off, and I wasn't here. I apologize. I'm sure you discussed this at great length last year.
It was a lot shorter last year.
Well, I was hoping, you said there's been a great deal of discussion about why the 4th strike versus the 3rd strike, ratcheting it up to a felony, and I was hoping you could give me, just for my benefit, kind of a brief synopsis of those discussions. What was the rationale?
Again, this was not, to be honest with you, my comfort level was at 3, not at 4. But you quickly learn around here, if you haven't already, that there's an art of compromise around here, and sometimes you got to give a little, get a little when it comes to what you want in a bill. Those 24 and 36-month misdemeanors were made as an accommodation, really, to the state court judges, the state court prosecutors, to give them a chance to do what they felt they needed to do. There was also a certain level of, well, do we really want to, with discomfort of, do we really want to make it the 3rd offense? Again, if you're asking my opinion, which doesn't matter very much compared to judges and prosecutors, the answer is yes. But I am comfortable that if that's what it takes in order to get a felony DUI, and again, not to be one of 5 states, including California and Massachusetts, that already have felony DUI, if that's what it takes to get there, and not keep treating it. At the end of the day, I guess this is what bothers me. It's an unusual argument that's always raised about DUI. We have in this state felony shoplifting. You can steal a book of matches valued at 2 cents from a Home Depot, and on your 4th one it becomes a felony. You carry a concealed weapon twice, it's a felony. You have your drawers down in public on the 3rd time, the 4th one's a felony. In none of those cases do you run the risk of killing a family on its way to vacation or coming home from church or synagogue because they happen to be at the wrong place at the wrong time. For whatever reason, that is a concern that people have raised. I hope that we will move ahead and bring our laws in line with the other 45 states that have adopted this. But if you're asking me why it happened to try and move this bill forward and get a felony in place because it's long overdue in the state of Georgia. And again, this is not just me, and it's not just Matt. It's a recommendation that's coming from the Young Adult Driver Task Force here in the state of Georgia. And in fact, some of our laws, we had to redraft this law to make sure we were being compliant with the federal law because the original draft of 336 was not compliant with federal law, wasn't tough enough.
Is 4 the norm in the other states, or is it just kind of across?
It's all over.
Yeah.
There are a lot of 4s, there are a lot of 3s. There are not very many 2s, but there are some of them.
Thank you.
Collins.
Thank you, Mr. Chairman.
This isn't some kind of joke that's played on the rookie legislators, is it? You all got together before? I just want to make sure.
Well, considering you being a distinct member of this freshman class, I would not do that to you. You and I both I have a couple of questions, and one, as you know, you and I have spoken, worked on this even during the summer. And the art of compromise for me would be to probably take out steps 2 and 3 and go straight from 1 to 4. My concern, however, is when you look at this, 2 questions. One, the easier one first. If we're changing, and I'm understanding correctly, line 29 on page 2 and wherever the other friendly amendment was, if you're changing the wording 24-month high and aggravated misdemeanor, would you not need to change it throughout the bill? Because you have this throughout the entire bill, 24-month misdemeanor. Why would you not need to change it, or 36-month? Why would you not need to change it in every instance where it's mentioned?
Because 24-month and 36-month misdemeanors are terms of art, and then it goes on to define what they are. And so that's really just in the definitional section as to what constitutes a 24 or 36-month misdemeanor.
I appreciate it, because that led to a wonderful segue to my next question. And you had gotten is my understanding 8 other states, is that the correct kind of? All right. Can you give me any information on these 8 other states? Did they, when they implemented a 24-month or a 36-month misdemeanor, did they also go into their code section, which I'm assuming is under their regular crimes and crimes and punishment, and change their definitions under their regular definition section of what a misdemeanor or a felony would be?
I'd have to defer.
He's behind you now.
Oh, that's a little unnerving.
Yeah, I can give you the states that did it and what they did it to, but I can't tell you procedurally if they went in and changed the definition that way or did it in a subsequent code section. We can answer at a later point.
Well, the concern I have in that is simply I want and I think that's my expression is this to be in place. What I don't want to have happen here is we get the first test case or second test case here, and we've got 2 definitions going here, and an attorney definitely easily brighter than I or others sit here and say, well, Your Honor, we got an issue here with the definition, and if I'd rather fix it now, if there can be, if there is a need for a fix, or if that's the way it's done in other states, than simply to let this hang out there and say, well, we'll just have to see it's done in other states. That's my concern, that you're going to get into an issue to where the very intent of this, which I fully support you on, is going to be hampered in implementation when this gets to actual being put into law, which my hope is to be there the day the governor signs it. So that is my concern. And I would take from our wonderful legislative counsel to you to answer what your ideas on that are. Because you're in 2 different code sections here. We never reference 16.1 in your bill. And 16.1 is the code section that references the definitions. Yeah, I'm wrong. And that's fine. I mean, I'm fully.
16.13 is the definitional section for Title 16.
Okay. So would we need then take it? Is there a definitional section? Which I didn't pull the book, so I'm just asking questions. So there would be a definitional section of 1710 that already has a felony and misdemeanor defined there?
I think it's 17-10-4. Is that right, Madam Counsel? I believe it's 17-4.
Okay. Okay. And I'm trying simply to ask questions now that undoubtedly will be asked later. And I mean, if I'm on the wrong path, I mean, I've been on better, roads and worse roads before. So. I think they were trying to get me an answer. So.
I think you got it. I don't think it.
Okay.
Misdemeanor is not defined for Title 40, which is why we defined it in 1710. In all honesty, though, the change, the high and aggravated nature change, I cannot say absolutely that it doesn't have to be changed elsewhere in this bill.
And as far as that goes, Mr. Chairman, should the will of the committee be a due pass recommendation, it's certainly something that we could fix at rules. That's a matter of wording.
I would prefer not to. I mean,
for the will of the chair.
Needs to be fixed here.
Thank you, Mr. Chairman.
Thank you, Representative Collins. Chairman Knotts.
I want to follow up on, because I'm concerned about this issue, and I want to be sure I understood, if I may, Mr. Chairman, I want to be sure I understood the issue on the definition of misdemeanor and felony. You're saying 1710.3 defines what a misdemeanor is?
It defines what 1710.3 defines what a punishment for a misdemeanor if it is not elsewhere provided in a code section. For example, there are lots of code sections.
What does it say?
1710.3 says, except as otherwise provided by law, every crime declared to be a misdemeanor
misdemeanor shall be punished as follows, and then it sets out the punishment.
Are any of those more than 12 months?
No.
Okay.
So in other words, if you just see the word misdemeanor anywhere in any of the titles, whether it's in Title 4 animals or Title
Right.
Title 32 with highways,
Right.
if you just see the word misdemeanor, we follow the definition in 1710, which is criminal procedure. As far as Title 16, if you see the word misdemeanor, it's a define for that title. And then the punishment is provided in Title 17.
Okay, but let me get this straight. So, but 16 is the definition of what is the category misdemeanor, without respect to whether what the length of the sentence is. Correct?
Yes, it doesn't give any definition of a sentence, but it is only for Title 16.
Okay, but Title 16 is a criminal code that this particular bill is going to be affecting, correct?
No, it's going to be in Title
40, okay. All right. Traffic laws, okay. But the criminal punishment the criminal punishments that we use in Georgia are either under because of the definition of a misdemeanor. We even go to different jurisdictions. I mean, if you're in state court, if you have a misdemeanor, and if it's more than 12 months, it's a felony, and you're in superior court. So we're in even separate jurisdictions based on the definition of the offense. And all these offenses that we have are categorized by what kind of a punishment we can impose on them in the Georgia code. Correct? Okay. So what am I still missing about this then? I'm not arguing with you. I don't get it.
I think one of the reasons why this is called a misdemeanor in this bill is to keep it in state court and to keep it in.
Okay, but you can't just change the name and thereby make it some other offense. It's either a misdemeanor or it's a felony, and you have to follow the definitions and the requirements that constitute that definition for a misdemeanor or for a felony, or else you have two different types of crimes and punishments.
And that's why Representative Liz created 1710.4.1 and 1710.4.2, which is pages 2 and 3 of the bill, where they're new animals. And we call them misdemeanors, 24-month misdemeanors and 36 misdemeanors, but we can call them Leviticus 2 punishment and then describe what the punishment is.
Okay, so what is a misdemeanor then? Definitionally, under the law, what is a misdemeanor?
I think that generally speaking, we think of a misdemeanor as something that's punishable by less than 12 months.
Exactly. Exactly. But so if it's not that, which we've all been accustomed to in Georgia as being the definition of a misdemeanor, then what is a definition of a misdemeanor now under this with this addition to what we have previously considered to be a misdemeanor? We now have another qualification, but not a change in the definition. So what is a definition after this law? What is the definition of a misdemeanor after this law?
Mr. Chairman, if I may,
Is anything we call a misdemeanor is a misdemeanor? Anything we give the name misdemeanor to is a misdemeanor?
If I may, Mr. Chairman, the response to that question is if you look at the code sections that establish the 24 and 36-month misdemeanors, you'll see that it's actually the converse. Anything that is not specified to be a 36 or 24-month misdemeanor is not a 24 or 36-month misdemeanor, and then would fall to the default of either being, depending on what the statute is, a felony or a misdemeanor.
I understand. I don't want to debate the issue, but here's the point. The point is there is a legal term called misdemeanor. What I want to know is how do you define a misdemeanor? Is it anything that we call a misdemeanor? Because you're saying there's a misdemeanor called a 24-month misdemeanor and a misdemeanor called a 36-month misdemeanor. Well, to me that means there's a 12-month misdemeanor, a 24-month misdemeanor, a 36-month misdemeanor, but the misdemeanor becomes whatever I want to qualify it with in terms of the years that you would serve as a punishment. So some misdemeanors are going to be as great as or more than a felony conviction in terms of sentencing.
Well, they could be, and in fact, you can have 10-year felonies that are punished as misdemeanors. So we have disparate treatments and leave certain things to the discretion of the court or the deference of the legislature all the time. So the answer is, it is what it is. You're absolutely right. We could define a misdemeanor in statute to be a felony and a felony to be a misdemeanor. The code is what we put in the code. So when we have a misdemeanor, That's not changing. If we insert new code provisions in there called a 24-month or a 36-month misdemeanor, then they are what we define them to be, and especially where we have gone the extra step of defining them as being this for these purposes.
All right, then. So then a misdemeanor is still an offense that's punishable. That's not a felony. That's what the title definition is. A misdemeanor is an offense other than a felony. That's what the title definition is.
For purposes of Title 16, and actually, I took a quick search while you were speaking, and there's only one place in the code where it says misdemeanor means, and that's in 1613. If you look at the top of that, it says, as used in this title, the term misdemeanor means, misdemeanor and misdemeanor in high aggravated nature mean any crime other than a felony. So for purposes of Title 16, you could, then I'm sure there are crimes within Title 16 that even give a lower punishment than 12 months. And it is a misdemeanor.
But any crime other than a felony is a crime that is punishable by imprisonment for more than 12 months. I just think there's a conflict in the laws there. Just definitionally, there's a conflict.
Well, that definition doesn't.
Okay. All right. I think I'm done. Thank you. Let me ask you this. On that same, if I can, Mr. Chairman, on that same issue, if it's more than 12 months, is it still considered county time, or is that state prison time after 12 months? And would the first 12 months be served in prison, or can it be served in county jail?
It depends. There's some of that depends on where you are to begin with. If, for example, a felony sentence is attached to this, you would serve that time in the state system. Otherwise, you would serve it wherever the court ordered you to. Theoretically, you would be, and which is practically true, as you know, Chairman Knox, from having practiced criminal law, practically speaking, with sentences like that, you're going to be serving them in the county jail, whether they're 12 months or 24 months or 36 months, because the state doesn't usually come and pick them up before their sentences are over.
But well, they do now, because we got after them and made them start coming to get them. So here's the other question: if you have, are we saying then that it's a felony, and it's still a misdemeanor, even if you're serving time in prison for more than 12 months, and it's not a felony?
You're treated, for all of the purposes except for the length of time, it's treated as a misdemeanor. So you would serve that time in the jail.
Okay.
If, however, it was attached to a felony, you would not serve that in the jail. You would serve that under the Department of Correction Supervision.
If it's attached to a felony, yeah. Well, does the language in here say that it would have to be run concurrent, or would that be at the discretion of the judge that it would be made to run concurrent? It could be, or could it be run consecutively?
I assume it could be. That would be up to DOC, I guess. And I actually don't think that's unusual. There are certain sentences when you are finished serving your state time and you're returned back to jail to finish serving out, whether it's a probation violation or something else, where you may have actually finished your time because you went to boot camp instead of serving the 5-year felony you should have on an HV. You wind up in boot camp and you're back out on the street, but you still got a jail sentence in DeKalb County, so you have to go back to jail. So that's not that unusual.
Can we require the Department of Transportation? You can tell where my head's been. Department of Corrections. Can we require them to perform the rehab and the treatment, and or the county for that 3 years that they're in prison or that they're incarcerated?
I mean, we can direct the Department of Corrections to do whatever it is we feel we need to do. They would have to comply with the law like any other agency would.
Have we considered what the additional cost will be to counties, for instance, for having people serve 3 years instead of 1 year and with no good time on a DUI?
Well, there's not no good time. It's reduced good time. So they get up to 4 days a month, I believe, is what the current high and aggravated treatment is. But they can't get any more than that. And whether there will be additional costs, I think that's way too speculative to know, because I would make the argument to you that HB 336, by providing DUI courts an opportunity to get recidivists, potential recidivists, out of the system, would actually decrease offense rates and decrease the costs. And keep in mind that you're talking about I think it's a $30 billion a year, I may be might have my figures wrong, 30 or $50 billion a year that DUIs cause in terms of cost. So if you're taking a drunk driver off the road, I would submit to you that you may be saving money rather than losing it.
I'm for trying to make DUI more effective, laws more effective than they are, and I don't mean just by catching them. I mean by how we treat them after we've apprehended them. But is there a mandatory? Did I read that there's a mandatory minimum in here as well?
There are some mandatory minimums. If you refer back to the color glossy, you'll see that on the first offense, depending on, you have 10 to 12 months. You can have that time probated if there's certain requirements for blood and alcohol content. If you look at the 24-month misdemeanor, there are certain requirements for community service time. It depends on when you've committed the offense, how recently it is. And again, if you look down at the first and second offenses, it depends on your blood alcohol content for how much your minimum time is. As you get to the third offense, it goes to how long it's been since you committed the offense. If you commit the offense 3 times within 10 years, it's a minimum of 120 days. If it's outside that period, it's 60. And if you've gotten up to a fourth, it's a year in jail minimum.
One further question, Mr. Chairman? If we have a sentence that's on a second DUI, without arguing about whether we should or not, but if we're looking at 90 days in jail and a 24-month jail sentence, and in most jurisdictions we're providing an attorney for indigent defense for these kinds of offenses, are we going to see some impact? Because if I'm a guy that can get a free lawyer on a 24-month sentence, I might be real inclined to do that. Say, I'm not pleading guilty. I'm not going to do any plea deals. I'm not going to do anything, particularly if I got a mandatory minimum I'm looking at.
Well, again, for the 24-month misdemeanor, keep in mind that the minimums you have to drop all the way down to the bottom colored boxes. If you've blown .08 or less, then it's a 72-hour minimum confinement, 3 days. If you've blown more than .08, it's a minimum 96 hours. So the judge can probate or suspend that time if he or she, in their infinite wisdom, decide to do that.
Thank you.
Thank you, Chairman Knox. Let me tell you where we are. The longer you've gone, the more questions you're getting. I had announced at the beginning that not only the chair but others on and involved with this committee had a 4 o'clock meeting, and I'm reminded that meeting not only will be at 4, but it will be in this room at 4. So we're going to end. I know I have members who have questions. We had people who had signed up. Mr. Hannawalt, Bob Dallas, Bob still, oh yeah, okay. Jessica Town, thank you, and Charlie McGarrahan. But we're not going to be able to finish this bill today. But I can assure you that we will finish it soon.
Thank you, Mr.
Anything to come before the committee before we adjourn so that we can clear this room and make it available for a 4 o'clock meeting? Please note, members of the committee, there's some information you need on the that's in your folder, so take that with you. Nothing else to come before the committee. We will stand adjourned and subject to call.
Thank you, Mr. Chairman.